Labor Law Online Workshop, Day 5. We are looking at dispute resolution and negotiations. This is your host, Dr. Tulipo Mwenfumbo. Remember, today's lesson is coming from the book entitled Labor Law Essentials, A Guide to Employers and Employees, written by Dr. Tulipo Mwenfumbo. And if you want to order this book, you can WhatsApp me on +260 976 18 12 53. +260 976 18 12 53. This course is brought to you by UNAP, Learning Without Boundaries. The mission of UNAP is to make education accessible, available, and affordable for all. You can apply or you can do many of the courses with UNAP. You can do the full-time courses, the degree courses, diploma programs, certificate programs, bachelor's and master's degree, and PhD degree. We house many universities. We are in partnership with many universities throughout the world. So today we are looking at dispute resolution and negotiation. And we are going to look at understanding dispute resolution process, conciliation, arbitration, and litigation. We are also going to look at effective negotiation techniques and strategies. Then we are going to look at managing workplace conflicts and grievances. So now, when we talk about dispute resolution, in labor law, what does it mean? This term refers to the process and mechanism used to settle conflicts arising from employment relationships, which includes issues like wages, working conditions, dismissals, and collective bargaining. So when we talk about disputes, we are talking about the process and mechanism used to settle conflicts arising from employment relationships. So this is when we talk about employment relationship, we are talking about the relationship between the employer and the employee. So that the process of resolving those conflicts or the mechanism of resolving those conflicts is the one that is called dispute resolution in labor law. It typically involves negotiation, conciliation, arbitration, and litigation through labor courts or tribunal, aiming for fair and efficient resolution of dispute between employers and employees. So the whole purpose of dispute resolution is to come up with a fair resolution between the employers and the employees. Now, dispute resolution process. So, when there are process that has to be taken before you even go to courts or you take up the litigation as a legal personnel or as a labor law promoters or as a labor law activist. You need to follow these channels because they are very important so that you must exhaust all the channels that you can be able to use in resolving the disputes between the employer and the employee. So number one, you have to do what is called conciliation. When you talk about conciliation, conciliation is a neutral third party facilitates discussions to reach a mutually acceptable agreement. So this is whereby now you mediate between the employer and the employee, and you must be a third person. And that is the situation where your aim is to reach at the acceptable agreement. This is often used in labor dispute for swift resolution. This is the cheapest and the best way of resolving labor disputes or resolving employer-employee disputes. Arbitration. When we talk about arbitration, is a binding decision made by a neutral third party after reviewing evidence common in labor disputes for final outcomes. So after reviewing the arbitration and conciliation or mediation, there are two different terms. Mediation just looks at hearing from both sides and also guiding them to come up with a resolution that is favorable for both of them. Now, arbitration, that is now getting the evidence that whereby this one will bring the facts and the other one will bring the fact. Then you make a decision basing on the facts given as evidence in that dispute. So, common in labor dispute for final outcomes. So, after arbitration, that is when now you give the report. Now, that report is the one that is also taken to courts, whereby the recommendation, like the labor officers, they mostly do that. And they'll write the recommendation to the court. They'll write, oh, we resolve this matter in this way, and they'll be able to take it to the court, and it will be also part of the evidence in court. Then there is also the labor courts or tribunal. Now, according to each country, they have got the way they do resolve their matters. So there is some countries, they have got labor courts, and other countries, they have got tribunals. So these are set courts which mediates between the employers and the employees, and they make the court decisions. So these are specialized courts handling employment-related issues, providing a formal forum for resolution. So we have talked about the three. You can do what is called conciliation or mediation, and the second one is arbitration, and the third one, it is the court procedure when resolving the disputes. Effective negotiation techniques in labor relationships. So for you to be effective in a negotiation as a labor promoter or as a labor activist, number one, you have to know the laws. You have to be familiar with the laws, understand the employment laws, collective bargaining, and also dispute procedures. That is very important. Then the second thing that you have to know is communicate clearly, articulate positions, interests, and concerns openly. So what you do when you are doing the mediation, or negotiation, you have to know and also allow the parties to know what you have to know what their grievances are and their interests. What are they trying to get? Where is the dispute coming from? So you have to understand both, and you have to articulate both positions. You have to know and be able to say them and say, oh, I've heard from this side that the challenge that they are having, the reason why you're having this dispute is this. And I've also heard from this side that the reason why they are rejecting, or they are doing this, it is because of this. So you have to let them to hear with empathy and reflect what both parties have given the point. Then focus on interest, not positions. When we talk about interest, is what do they really want? What do these parties want? Unlike the position, it is where one wants this. It is just what I want, but the interest is what is the real thing that these people want, or this position, this party want, and what is it the really thing that this party want. Seek win-win solutions that meet underlying needs. So when you are resolving the disputes, there should not be one to be a winner and one to be the loser. There must be win-win situation. That is whereby each party must feel satisfied and must feel that my interest has been tackled with and has been resolved. Then interest-based bargaining. So interest-based bargaining, that is where now you have to negotiate, step forward or step backward, and the other one step backwards, and come up with a place whereby, with a neutral place where there is each of the sides, they are satisfied and also they have not stepped on the other side's toys. Now, managing workplace conflicts and grievances. Number one, follow procedures. Adhere to collective bargaining agreements or company policies. So now, when you are dealing with the employer and the employee dispute, you have first to look at the contract. What have they agreed on? What is it? If it is the payments, you have to look at what did they agree on. So those policies has to be followed. So you have to tackle on those. Has this been followed? Have you paid him according to what you agreed? Did you work according to what you agreed? So those are the things that has to be followed. The other thing is that you need to document everything. Keep records of incidents, talks, and agreements. So you should have kept the record. You should keep the records of everything, both as an employer and as an employee. You need to keep records. One thing that I've observed in my career in this area, whereby when I'm sitting the employers and the employees, or when the employee comes with a dispute or comes with a challenge with the employers, I ask them, where is the contract? They'll say, no, I signed, then I gave it. What was contained in the contract? They cannot even remember. So as the employees, it is very important to keep the records. You should have a copy of the records, the copy of the agreement or the work contract that you have, which should be for both sides. Now, one thing that I've seen, most of the employees, they don't take interest in remaining with a copy. As a result, the employers get the copy and the employee has no evidence of what they agreed on. So any paper, any letter that you have given by the employers, it has to be kept, and you need to keep it well and file it so that in the near future, or when the dispute comes, you'll be able to talk about those issues that you agreed on. So document everything, keep records for both as an employer and as an employee. Involve HR management or human resource management. Get support when needed. So as an employee, you are under the human resource. The human resource at work is there to stand in between the employers and the employees. That's the work of the human resource, or who is called now as the capital manager or human capital manager. So now human resource is there to ensure that the dispute, or to create the working environment. So as an employee, you need to first to seek guidance from the human resource and the disputes from the human resource, though he stands on the management side, but he is trained to understand the workers' needs and the workers' desires. Explore the mediation. So, mediation, conciliation, and arbitration for effective resolution. So you have to look at what should be done. Is it mediation? Is it conciliation? Is it arbitration for effective resolution of the disputes? Now, as a labor law activist, you need to understand the key labor law concepts like collective bargaining. That is negotiating employment terms between employers and employees. Then there is also what is called unfair labor practices. That is the actions that disrupt organizing, bargaining, and concerted activities like the strikes, whereby when the employers cannot adhere to what the employees wants or what they desire, and the employers wants to use up their powers so that the employees may not be able to express their grievances. There is what is called strikes. That is what is called action that disrupt organizing or bargaining or concerted activities. That is whereby now the employees, they can go on strike so that now the employers will be able to hear from them. Then also, there is also what is called grievances procedures. So this is structured processes for resolving disputes and complaints. So as an organization, there is the dispute resolution procedures. If the managers or if the employers cannot get what the employees are doing, the employees will write the employers, and they'll send the representatives, which are labor union. So they will send the labor union to negotiate, and if they cannot adhere to them, then they'll use the procedure like they'll be able to go slow. If they don't also adhere to that or get to that, then they'll go on strike. So then if they go on strike, they are fired, then they are going to seek for arbitration. If it doesn't work, then they go to court. So those are the structures in resolving disputes. What are the best practices? The best practices is to stay updated. Both as an employer and as an employee, you need to stay updated on the issues of labor law. Review labor laws regularly for compliance. So you have to understand the labor laws for compliance sake. Train your team. Know, understand. Let the educate on laws, dispute resolution, and conflict resolution. Foster positivity. Promote open communication and respect between employers and the employees. So we have looked at understanding dispute resolution process, conciliation, and arbitration. Then we have also looked at effective negotiation techniques and strategies. And we have looked at managing workplace conflicts and grievances. Thank you so much, and God bless you. Remember to get this book, Labor Law Essentials, a guide to employers and employees, written by Dr. Tulipo Mwenfumbo. Remember to register in any of our programs. with UNAP. UNAP, it's an online campus which houses universities and colleges. You can be able to do different programs with UNAP, and you can be able to download this UNAP app and do